In this next lecture, we're going to look at a specialized form of international business law called international business transactions. And the transactions that we're going to discuss are primarily going to be the buying and selling of goods across international borders. Now, in the modern world, sellers and buyers are strangers for the most part. Oftentimes, they've not had a prior course of dealing between themselves, and certainly the level of trust between the two is going to be minimal. Now, you will be aware, of course, that there are always risks associated with any sales transaction. Things like failure to get paid, or failure to deliver the goods, failure to receive the type and quality of the goods that were ordered, failure to make proper credit arrangements, any number of risks, and we're going to be discussing more of those today. But obviously there are going to be risks associated with a sales transaction. Now these risks are magnified in the context of international transactions. Possibility of severe injury because of the international nature of the transaction. Nevertheless, what we're going to try and do is to study the risks so that we can minimize them to the greatest extent possible when conducting business. So in this lecture, we're going to look at things like what are the expectations that the parties to a transaction may have, what are the primary forms of international business, and what are the common risks to international business. Now we start with the notion of expectations. What are the expectations that each side in the sales transaction may have? Well, let's start with the buyer. We understand that the buyer has certain expectations. The buyer wants to receive the goods that she has bargained for, the goods that are of the same size, quantity, type, quality that she bargained for. The buyer is also going to want to confirm that the goods are satisfactory. And how do we do that? Through inspection. So a buyer is going to have an expectation that she will be able to inspect the goods prior to payment. Finally, the buyer doesn't want to pay for the goods until inspection is complete. Otherwise, the buyer would have paid for goods that are not the goods that she ordered and that she may not be able to use. So those are the buyer's expectations. Now the seller also has expectations. The seller wants to receive payment as efficiently, as expeditiously, as promptly as possible. Sellers want to get paid in any transaction. If you ever listed anything on eBay or Craigslist, your number one concern is, how do I get paid? Will I get paid? Now the seller also doesn't want a long waiting period in order for this inspection to occur. The seller not only wants to get paid, but wants to get paid as soon as possible. And the idea of taking an extended amount of time to wait for an inspection is something that most sellers are not going to agree to. Now, finally, the seller wants to avoid shipping goods if there's a possibility that the buyer may reject those goods on the other end. Because once a seller ships goods, he has parted with the goods and has not received payment. And he may have difficulty recovering the goods if, for whatever reason, the buyer rejects the goods. So those are the expectations of the seller. Now, let's look at these risks of a transaction in a domestic context, in a sale, maybe within the United States or even within one state. Now, in a domestic sale, the risks that may occur are manageable. They're manageable, first of all, in the sense that both parties have access to a great deal of public information. We have things like credit reports. We have newspapers, media. We have word of mouth. It's quite easy to get the information on a company when that company is located next door or in a state just a couple hundred miles away. Furthermore, in a domestic context, both parties can inquire into the reputation for honesty or dependability of the other party to the transaction. If a disagreement arises, well, the parties are going to be able to discuss it. They're going to be able to communicate. They can do it through a face-to-face meeting, a phone call, through email, through a text, through Skype, through a Google Hangout. There's many, many ways that the parties can meet to discuss a conversation. And in that conversation, they're likely to be using the same language. The same language will apply for both. So you avoid the whole notion of having a possibility of the meaning of the phrase not being clear because of a problem with the language. Now, we talked about legal infrastructure before, and again, in a domestic context, even involving sales between different states, the differences in the law are going to be relatively minor differences. I mentioned that 49 out of the 50 United States have what's called the Uniform Commercial Code as the law that governs the sale of goods. That law is pretty much the same in every state. Certainly the basics are. And finally, the differences in the court systems are relatively minor. Every court, including Louisiana, tends to work the exact same way. So a court in Alabama will function just the same as a court does in California. Same basic set of rules will apply. Attorneys may be able to practice easily in both courts. So the differences in court systems, the differences in achieving the remedy are going to be relatively minor. Now, in an international sale, of course, those risks are going to be much higher. We start with the notion the expectations of the parties are the same, but the risks are going to be much higher. Starting with things like communication. Communication is going to be much more difficult when you're talking about different countries. Starting with the basics, a time zone, where the time can be very, very different. I know that I go to France every year for the summer. And you get over there and you're 8 hours ahead of the United States, and any conversation with the United States, you realize there's only a small window of time in which you can accomplish that conversation because of the time difference. If you go further abroad, if you go to Thailand, for instance, in Thailand the time is about exactly 12 hours different. So 8 p.m. is 8 a.m. in the U.S., and the difficulties involved in that are tremendous. You are literally living on the other side of the world in a completely different time zone. There's going to be language issues as well. You know, you often hear that English is the law of business, the language of business is English. Nevertheless, there's lots of room for ambiguity. Even if both parties are using English, English may not be a native language for either party, and there are going to be plenty of opportunities for ambiguity. There's going to be greater difficulty in determining trustworthiness. How do you determine trustworthiness? You're going to have to rely on sources that you may or may not know that whether they're trustworthy. There's going to be greater difficulty in determining creditworthiness, and obviously in an international business transaction, creditworthiness is a major part of that decision to whether to enter into the transaction or not. The risks of non-performance are much greater, meaning either failure to deliver or failure to pay. Those are non-performance. Times and distance changes can be huge obstacles. We have the problem of a choice of law. What law will apply? And in a subsequent lecture, we'll talk about choice of law questions. And choice of forum is going to be another issue. Who is going to hear any dispute that arises out of non-performance?